For our module on sexual harassment, you will need some basic information about the law that applies. That law is Title VII of the Civil Rights Act of 1964, and this is the law that applies to pretty much most, if not all, employers through state initiatives, and it prohibits discrimination against employees and applicants on the basis of race, sex, color, national origin, and religion. We also have provisions against discrimination on the basis of genetic information. We won't be talking about that. You're wondering, what about age and disability? Those are covered by other law, specifically the Age Discrimination in Employment Act and the Americans with Disabilities Act as amended. We are not going to be getting into the particulars of the Age Discrimination in Employment Act today, but please be aware that any discrimination against someone who is 40 years old or older and anyone who is an employee with a disability or is regarded as having a disability, that kind of discrimination is prohibited, and the harassment protections we will be talking about today also apply to people on the basis of those protected characteristics as well as the protected characteristics we already discussed of race, sex, religion, color, and national origin. Now, as we're talking about harassment principles and how they arose under Title VII and how they apply in the workplace, we are going to be crystallizing our discussion on sexual harassment because that is how the harassment law generated through the courts originally was through the concept of sexual harassment. However, the concepts we're going to be discussing today about harassment apply also to all of the other protected characteristics we have talked about. Accordingly, it is illegal for an employer to allow harassment of someone on the basis of their race, of their age, of their disability. Now, to understand all of the concepts we're going to be discussing, we are going to focus on sexual harassment. And when we talk about sex as a protected characteristic under Title VII, bear in mind that we're talking about gender, discrimination or harassment on the basis of the fact that someone is male or someone is female. On a federal level, under Title VII, it is unsettled at this time whether sex includes sexual orientation or transgender status. Some states and some cities have specifically adopted laws that say that there cannot be any discrimination or harassment against someone on the basis of their sexual orientation or on the basis of their transgender status. Accordingly, as you will probably hear me say many, many times in class, as well as perhaps in this lecture, that it is very important to be aware of your local and state laws of wherever you have operations to be sure that you are complying with whatever additional protections those states and localities may provide. Now, when we're talking about discrimination, we're talking about treating someone differently, particularly worse, in connection with the terms and conditions of their employment. And when we talk about terms and conditions of employment, we're talking about things such as hiring, firing, pay, promotions, demotions, things like that. For example, if you choose not to hire someone because of their race, or if you choose to pay someone less because they're a female while you are paying male employees more, then this is discrimination and it is illegal under Title VII. So how do we get from terms and conditions of employment, such as being fired or being paid less, to harassment? Where does that line come in? And the way that that came about was the courts recognized that if someone's work environment is made so hostile or made so abusive by conduct being directed at them on the basis of their sex, then that is a change in their terms and conditions of employment. So how do we get to hostile or abusive conduct? What we're looking for are actions or words that are based on the person's sex. In other words, they are sexually charged. They're about someone's body, or they are suggesting attraction or requesting sexual favors. We will get into some examples in just a couple of seconds. Now, these actions or words cause the person discomfort, and they are unwelcome. Now, when we say unwelcome, we mean that the person is not happy this is happening to them. Unwelcome is different from not being consented to. The difference between welcome and consent is that someone may appear to consent to this conduct by going along with it, joking with the people, not raising objections to the conduct that is happening. It doesn't mean that the person is happy that this is happening. It may still be unwelcome, but they are just afraid to speak up. And so that is why we look at whether something is unwelcome as opposed to looking at whether someone consented or did not consent to the activity in question. Now, we're not looking just for one action or one word that meets this definition. Instead, we're looking for conduct that is either severe or pervasive. Severe is something very dramatic, very intense that happens, such as a physical assault, rape, or someone grabbing someone's body parts in a very traumatic manner. And if there is something severe like that, then we only need it to happen once for it to be harassment. If something is not severe, it is on a much milder scale, such as a joke or staring or leering or a request for a date, a very minor touch at the shoulder or something like that. If it's something smaller than a severe incident, then in order for it to become harassment, it has to be what we call pervasive, meaning that it has to happen a lot or frequently enough to create a change in the person's work environment. Now, the concept of pervasive helps us understand why companies try to stop potentially harassing actions as early as they possibly can. Because if something is milder than a full-on severe assault or something like that, if it is a joke or one isolated incident, then a company has it in their best interest to try and stop it early on when it's just happened once or twice. Because if they allow it to continue, then it may actually rise to the level of being pervasive and thus illegal harassment. So this is why we see employers' policies saying that it's a violation of the policy for any of these potentially harassing actions to occur. Now let's take a step back and look at some examples of actions or words that could potentially become illegal harassment. Things like jokes of a sexual nature, pictures, perhaps pornographic pictures that are being displayed on a computer, a phone, on the wall. We're talking about if someone is staring, touching someone. It doesn't have to be touching of body parts like genitals. It could also be maybe repeatedly putting their hands on someone's shoulder or grabbing their hands or putting their hands on their back or their lower back. Anything that the person is not welcoming, essentially. Requests for dates, especially if it becomes repeated, especially if the person has said no once and then they're repeatedly asking on dates. That's problematic. And also, as we mentioned before, assault. That's going to rise to the level of being a severe incident that in and of itself can be illegal harassment. Also, we're looking at someone commenting on clothes, particularly the way that the clothes reveal body parts or fit the person, commenting on their appearance, discussing sex, discussing their own sex life, inquiring into the sex life activities of someone else. And then inappropriate communications, perhaps an email or a text that has a lewd comment in it or makes a reference to sexual activity, and also inappropriate social media activity if it is directed towards the person in question or even just directed out and available to be seen by other people in the workplace. Those are all additional examples of conduct that can potentially become illegal harassment. Now, the next step in our analysis for our purposes, and this would be the next step in a court's analysis or the EEOC if they were considering a claim of harassment, the next step is to look at what is the relationship between the person allegedly committing the harassment and the person who is subjected to it. Are they co-workers on equal footing? Or is one person in a position of authority, someone who carries more weight in the company, someone who actually has the power to change the terms and conditions of the person's employment. In that situation, the person who is being subjected to the harassing activity may not feel that they have the power to speak up, the power to ask the person to stop. They may feel that they have to tolerate the behavior in order to keep their job or in order to avoid making waves or having problems with their employment down the road. Contrast this to the situation where the people are on equal footing as co-workers, or perhaps the person doing the harassing is a third-party vendor or a customer, someone who does not have authority over the person's terms and conditions of their employment. They are on conceptually more equal footing, and it may be easier for the person who is the victim of the harassment to speak out and say, knock it off. I don't like this. This makes me uncomfortable. The law essentially puts a higher burden in these coworker harassment situations on the employee because the company is not going to be liable for the harassment unless the company knows or should have known about the harassment and then failed to take prompt and appropriate corrective action. So if the company has no knowledge that this is going on, then it's not going to be liable for the harassment. It is incumbent upon the employee to come forward to someone and say, hey, this is happening and I don't like it and I need it to stop. If the employee doesn't do that, and if the company has no reason to know that this harassment is going on, then the company is not going to be legally responsible for it. So what is prompt and appropriate corrective action in this scenario? It is any kind of corrective action taken by the company to make the harassment stop. It doesn't matter exactly what the company does. There is no mandatory discipline to take against the person who is alleged to have done the harassing. As long as the action the company takes makes the harassment stop, then that is sufficient under the law. So let's revisit the scenario where it's a person with authority over the terms and conditions of the victim's employment. How are we going to analyze a company's liability under this scenario? Here, the courts do not put as strong of a burden on the employee to essentially speak up for themselves and take care of themselves. Because remember, the person may be reluctant to speak out for fear of losing their job because the person who's doing the harassment has authority over them. In fact, if the supervisor or manager with authority over the victim actually exercises that power to change the terms and conditions of the person's employment for better or for worse, then the company is strictly liable for that harassment without any chance of having a defense. In other words, the person has no obligation, the victim has no obligation to come forward and talk to anyone. The mere fact that they had a change in their terms and conditions of employment by the person doing the harassing, that's enough to make the company liable. Now, what scenarios would we see this under? This would be where the boss says to his subordinate, you have to sleep with me or I'm going to fire you, and then he fires the subordinate. The company is going to be absolutely liable for sexual harassment in that situation. And it doesn't have to be a bad change in the terms and conditions of employment. It can be a positive one. Let's say that the boss says to his subordinate, if you sleep with me, I will give you a promotion. The sexual activity occurs and then the person receives a promotion. That is also illegal harassment and the company is going to be strictly liable for it. Now, if we have a situation where there is a supervisor or manager with actual power, but there is no change in the alleged victim's terms and conditions of employment, then there is some responsibility placed upon the employee, the victim, to take action to do something to stop the harassment. Now, what kind of situation would this be? Obviously, we're not dealing with a request for a sexual favor being turned down and then a job being lost or some kind of job benefit occurring because of acquiescence to the sexual activity. Normally, in these situations, we're looking more at the other types of harassing activities, such as the pervasive jokes, staring, touching, and perhaps requests for dates. In this situation, if the company has an effective policy and procedure against sexual harassment and the person fails to follow that policy and procedure, then the company is not going to be liable for the harassment. The reasoning is that the person had an opportunity to make their situation better by going and talking to someone, and they failed to do so. This raises the very important question of what is an effective harassment policy and procedure. There needs to be not just a policy that defines harassment, gives examples, and specifies that the company's policy prohibits this kind of action, but there also needs to be a complaint procedure that the person can easily follow to get their concerns about the harassing activity to the company so that the company can take action, and the company does indeed actually have to take action. Essentially, an effective policy and procedure empowers the employees to know that they can go to someone to raise their concerns and to get the behavior to stop. It is crucially important for a harassment policy and complaint procedure to have a number of different avenues for the employee to follow to raise their concerns to the company. Of course, we want them to feel comfortable talking to their supervisor, but what if their supervisor is the one doing the harassment? So having the open door to human resources, having an open door policy to talk to anyone else up the chain of management. Perhaps you have a 1-800 number that the person can call to make a complaint anonymously. The more avenues that the person has to raise their concerns with the company, the harder it is going to be for them to explain why they didn't do so if they later sue the company. If they had a number of different ways they could complain about the harassment to the company and they never did, it's going to go very far for a company to defend itself, to say either it was a coworker harassment situation, but we didn't know about it. How could we take prompt and appropriate corrective action if this person never told us? They could have gone to ER, they could have talked to their boss, they could have called our 1-800 number, we have this open door policy. They never took advantage of any of those avenues in order to come in and tell us what was going on. So how could we fix the situation? And then if we're dealing with a supervisor and subordinate harassment situation, assuming that no tangible employment action against the person's terms and conditions of employment have happened, then that person, if they didn't follow any of that procedure, they didn't go down any of these avenues of complaint, then it will be shown that they acted unreasonably. They could have talked, again, they could have talked to human resources. They could have gone higher up in the chain of command through the open door policy. They could have called this 1-800 number, and they never did. They never took advantage of any opportunity to stop the harassing behavior, and therefore the company is not liable for it. In addition to having multiple channels of communication to raise concerns about harassment, other things that are very, very important for an effective harassment policy and complaint procedure are that the policy is visible. It should be posted. It should be in any kind of employee handbook that is available in paper form or online. It should be the subject of training repeatedly. This is the kind of training that needs to happen on someone's very first day. Their orientation training should include sexual harassment training, and they should be trained every single year as a refresher. Especially supervisors and managers must have this training at least once a year to keep it fresh in their minds. And it is very, very important that a company maintain proof of the harassment training that has occurred and who was present in the training. You want to have sign-in sheets. You want to keep those. You want to make sure you have electronic copies of this as well, in case the paper copies get lost. You want to be able to prove at a later date that someone was aware of the policy so that they didn't commit the harassment, or that they're aware of the policy and they knew that they needed to raise their concerns with the company and perhaps they failed to do so. Further, to be effective, the company actually does have to make a quick response or enact a quick response to any kind of complaint that is raised with the company, and there needs to be an appropriate result. The result does not have to be exactly what the victim wants to have happen. It is just whatever is necessary to get the harassment to stop. For example, let's say you're dealing with coworker harassment where someone has been making some inappropriate jokes and a few inappropriate comments, and the company needs to take action to make it stop. You may have the person who complained about the harassment come in to you and ask that the person be fired because they don't like these comments that are being made. Well, firing may or may not be the appropriate result in this situation. It may very well be the appropriate result if this person has been counseled on this type of activity before, but what if it is a first-time offense and the person didn't realize that they were doing something that was against the company's policy? In that situation, perhaps a written disciplinary notice would suffice. The question is, does it make the harassment stop? And that is why it's important also for the Human Resources Department to follow up on any kind of sexual harassment complaint after it has been investigated, after whatever appropriate result has been taken, or what appropriate action has been taken. It is very important for the HR department to touch base with the person who complained about discrimination or about the harassment later on and say, hey, has this stopped? Is everything better now? It is important to keep an eye on these things. It is also important that the company makes sure that no retaliation happens against the person who complained about harassment. They should have an anti-retaliation provision written into the sexual harassment policy. In addition, if it is a supervisor who is the subject of the harassment complaint, it is very important for Human Resources to tell the supervisor that they cannot retaliate against the person who made the complaint. And Human Resources should request to be involved in any kind of discussion of disciplinary action or performance appraisals, which may have a negative impact on the person's job prospects. It is very important that HR be involved in any of those types of discussions with the supervisor after a complaint has been lodged, just to make sure that the supervisor isn't doing anything retaliatory against the person without justification. There needs to be some sort of legitimate business reason for any kind of negative action taken against the person who complained of harassment. And HR can help the supervisor navigate that delicate situation shortly after a complaint has been made. It is also important that the Human Resources Department follow up with the person who made the complaint of harassment to make sure that no retaliatory action has occurred. So that completes our short discussion about sexual harassment and what it is and how to analyze it if it happens in the workforce. If you have any questions about anything we've discussed, please email me at jacobs.610@osu.edu or jacobs.osu@gmail.com, and I look forward to meeting you in class.